I'm glad so many of you have joined me in benefiting from this amazing symposium and have stuck it out to our last panel of the day, the Welfare Queen and the Racing of Poverty. As you'll see, we're well worth the wait. So thank you to Professor Camille Rich for bringing together this remarkable set of scholars around such a timely, important, and fascinating theme. And thank you, of course, to Mira and her team for facilitating and sustaining this endeavor, and to Gould for hosting. And to my co-panelists, I'm honored to be here on the stage with you, especially since my price of admission is mostly to listen and to learn. And to leave as much time for Q&A, I'm going to not give the extended and glowing introductions that my co-panelists deserve, and instead be very brief. So we're going to begin with Cheryl Harris, who is the Rosalind and Arthur Gilbert Professor in Civil Rights and Civil Liberties at the UCLA School of Law, where she directs the Critical Race Studies program. And she'll be presenting remarks entitled Whiteness and the Racialized Engendering of Poverty. Then we'll hear from Deanna Williams, Assistant Professor in Law and History here at USC, in a presentation entitled Civil War Widows, Pensions, and the Early Racialization of Family Assistance Programs. And our final presenter will be Kimani Paul Emile, Professor of Law at Fordham Law School, presenting on reconsidering criminal background checks, race, and redemption, reconsidering criminal background checks, race, and redemption. I don't usually get tripped up even reading my own things, but I will now hand it off to Cheryl, who I'm sure will be very articulate.
Uh-oh.
Pressure.
Lots of pressure, particularly since it's 4, it's late. We're the last ones. We're standing between you and, well, whatever. So I really want to echo everyone's thanks to Camille. I happened upon Camille at another event, and she asked me to be here, and I hesitated for just a heartbeat because I wasn't really sure that where my head was in terms of the work that I was doing necessarily related, but even though I'm still not sure, I'm here and very glad to be here because it's really been an incredibly generative conversation and made me think about sort of, you know, those ideas that you have that you sort of partially develop and you leave them to the side. And now it's sort of all really sort of coming back into focus. So thank you, Camille, for doing this, and to the staff that did such a wonderful job in pulling this together. How much time do I have?
15 minutes.
Okay. All right. I just wanted to be clear. So in my remarks, I want to consider how the welfare queen as a racial frame both undergirds and constructs whiteness, and in turn how whiteness participates in and enables the construction of the welfare queen. And these are very tentative remarks. So what do I mean by whiteness? I mean to refer not to individual racial identity or to either as that identity is claimed or attributed, but rather to the organized system of benefits and privileges that are accorded to whites as a class. So in my thinking, black and white, as I'm speaking about it, are really ideological concepts, not phenotypical characteristics or even racial categories, although they can function that way. And the way that I'm thinking about it is the way in which black and white are relationally constructed, that is, with whiteness marking a position of relative privilege, and it is marked by its distance from blackness, and blackness is then a locus of legal and social disadvantage and subordination, marked by its distance from white privilege. So given myriad differences of gender, social class, sexuality, ethnicity, and ability, the privileges of whiteness, of course, are not evenly distributed, nor are they equally accessible to all individuals who identify as white or who are perceived as white. And indeed, this is something that Camille and others have worked on and spoken about. The marginal benefits that are accorded to whites who are at the bottom of the economic hierarchy may be difficult, if not impossible, to discern, at least as measured by material wealth. Yet, returning to Du Bois' classic study on race and class, Black Reconstruction, he noted that for the white working class, racial identification as white became crucial to the way that it thought of itself and conceived of its interests. And symbolically, of course, the historians tell us it was defined in opposition, free labor defined itself in opposition to slavery. There were obvious material benefits because of the racial stratification of the labor market. it created racial cartels that protected certain jobs as white. But his point was that even when the white working class did not collect increased pay or other forms of material benefit, there were real advantages not paid in direct income, famously the wages of whiteness, what he called the public and psychological wage that was vital to white workers. So, to quote him, they were given public deference because they were white. They were admitted freely with all classes of white people to public functions, to public parks. The police were drawn from their ranks, and the courts, dependent on their votes, treated them with leniency. Their votes elected public officials, and while this had small effect upon the economic situation, it had great effect on their personal treatment. Obviously, if we update this sort of accounting, we might craft it somewhat differently, but conceptually, what he's getting at is that there are multiple ways in which we accrue social capital. And there's ways in which we can think about it at both the material level as well as the psychological level. And the key point here is that whiteness, at least as I'm conceiving of it, confers relative benefits on all whites, even those who are burdened by class oppression, and I know that's a tough one. But whites that are poor are both subject to the privations associated with their class conditions and at the same time insulated from the harms associated with blackness. And this is what makes this a complicated thing to talk about poverty in terms of its racial dimensions. In this way, regardless of the failure of whiteness to deliver equally to all whites, whiteness still allows and facilitates the creation and maintenance of what I've sometimes called a cross-class coalition that coheres ideologically, even as it diverges in terms of the material impact on individual whites. One way of putting this is, as Derek Bell famously argued, the one irreducible privilege of whiteness, even for people at the bottom of the economic spectrum, was to never have to be black. So if we understand frames and framing the sort of the conversation that we're in, the welfare queen, of course, constitutes one of the most enduring racial frames. And basically my argument today is that one of the reasons for that durability is the infinite flexibility of it in a lot of dimensions. So I won't go into the whole thing here, but the idea about frames or frameworks and what we really mean when we're talking about that is also fascinating, and I'm glad there's some sociologists in the room who can help me get this right. But in classic terms, Goffman explained it as providing an answer to the question, what is it that's going on here? That's what a framework is. It sort of helps us interpret facts. It's what lies between the facts and our perceptions. It's a mediating structure that allows us to make sense of the world. It's a kind of architecture that tells us what facts make sense as well as what sense to make of the facts. So stereotypes are a particular way that frames get instantiated. And a racial framework is frequently dependent upon stereotypes because that's the way that we construct and store the psychologists tell us, cognitive structures or pictures. But by racial frames, I think they operate at both the cognitive sort of micro level as well as the macro societal level. And it's more on that level that I want to focus. That is that where I see this as sort of being a way in which the welfare queen's durability is tied to this flexibility. So as has been well documented, the welfare queen is formally colorblind. It's a formally colorblind category. It doesn't say the black welfare queen, but it doesn't have to, right? It's irretrievably racially encoded as black. And in this way, it enters into and participates in the ongoing relational construction of whiteness as against blackness. It's part of an array of racial frames in which racial inequality and poverty in particular is attributed to black cultural dysfunction. And it's a pre-existing frame that is tied to notion of colorblindness, under which racial disadvantage is understood as being the function of something other than racism. Colorblindness basically, I think somebody else, maybe it was Karen, alluded to the Heritage Foundation's description of poverty isn't really poverty. There's another part of that which it's actually deeply tied to, which is colorblindness, which is when we see racial disadvantage, that's not a function of racism, that's a function of something else. So if we've moved into a period where notions of biological inferiority are at least formally repudiated, and I actually probably want to put a question mark behind that. I used to say that with some degree of certainty and feel like I could say that that's mostly off the table, but I'm not sure about that. Racial inequality is then a product of black dysfunction. And the issue is not blood, as it was in the past, but behavior. So were black people to behave correctly, that is, to engage in normatively appropriate conduct, work hard, attend school, avoid drugs, resist crime, save money, then they would transcend their current social status. But under colorblindness, then black people are not inherently or biologically inferior to whites, but culturally deficient and insufficiently assimilated. And one implication of this claim is that black disadvantage is a product of culture and racial inequality that will only disappear when black people are fixed. So obviously this is a racial script that's also engendered, and the role of black women is central to the notion of cultural dysfunction, and it's one that can be understood to lie within the idea of racial patriarchy, of which of course the origins of which lie in slavery. I won't go into this because I would assume that having heard Dorothy and some of the other people, this is all, I think, reasonably well known to this group. But the point is that if we understand that the particular form of slavery enacted in the Americas and here in the United States was a form which was both racially defined and a natal condition passed through the matrilineal line, this gets legally encoded through such principles as that the presumption to be black was to be a slave, and the notion that a child of an enslaved black woman was a slave. This allows for the reproduction of one's own labor force without reliance on the slave trade. And it also the law endorses this system as a principal instrument of control and gets encoded into our legal DNA, the architecture, the Constitution. As Houston Baker once put it, a document that in a sense writes itself on the enslaved body of the African. So slavery as a system of property then does not only structure race, it configures and structures social and legal hierarchies of race and gender. And slavery in this sense becomes a primordial site for the production of racial patriarchy. What I mean by that is that it describes that social, political, and conceptual system that entrenches the ideology of white supremacy and white male control over all women's reproduction and sexuality. But black people are racially subordinated then through lines that are articulated within and through gender, and all women along lines that are articulated within and through race. Then the constructions of race and gender that emerge from slavery are not wholly separate either as lived realities or as analytical categories. And the enactment of racial and sexual oppression within slavery then spawns ideology of womanhood that create oppositional images of black and white women and configures the conception of womanhood along racial lines. I'm going to skip here because he's already told me I got 5 minutes. In this way, the conception of womanhood is deeply wedded to slavery and to patriarchy, and the conduct of all women gets policed in accordance with patriarchal norms and in furtherance of white male power and control. As ungendered subjects, to use Hortense Spiller's term, black women then performs crucial labor across multiple levels, and it's this flexibility of black women's labor that I think we can see in the concept of the welfare queen. So within a society of rigid gender roles, black women's labor is really, really flexible. She works in the field alongside men performing men's work. She performs domestic labor in the master's house as well as for herself and her family. And her reproductive labor is also fully exploited as her children increases the property of her master. Sojourner Truth's narrative gives an account of her owner's boast. That wench is more valuable to me than a man, for she will do a good day's washing in the night and be ready in the morning to go to the field, where she will be as much at raking and binding as my best hands. So you see this ability to sort of transcend the gendered divisions of labor that makes black women even more valuable in a certain sense than black men. If we think about the Lupita Nyong'o's character in 12 Years a Slave, you see a similar kind of evocation in that cultural reproduction, where she's called the queen of the fields because of her prodigious capacity to work like, or in many instances, better and harder than a man. This racial frame of the welfare queen then can be thought of as a central figure in racial patriarchy and in upholding whiteness. Like her enslaved ancestor, the welfare queen's labor is infinitely flexible. She's a gendered subject because it's her reproductive capacity that she's allegedly manipulating to lay claims on the state for support, but she's not a mother in the sense of a parent. Indeed, and in that sense, she's simultaneously ungendered. Legally and culturally, then we can think of the ways in which black women have been positioned outside of the category of women. Women becomes a category that's racially encoded as white. And as a consequence, Solicitude and concern for women, as expressed through the social welfare system, has typically, of course, focused on white women because that's the category of women. But it's worth noting that this care and concern is highly unstable, particularly for the poor or otherwise non-conforming women. And this is the way in which legislative disregard and active hostility towards poor black women ends up extending beyond its original target. It's a sort of a drive-by shooting situation, right, or collateral damage, if you will. The welfare mother as a black subject serves as a counterpoint to and locator of whiteness. And in this way, there's another aspect in which I want to argue that there's a kind of flexibility attached to this. So whiteness in this context, and when we're talking about poverty, is a racialized construct, or I should say poverty is a racialized construct, and whiteness functions in a kind of dual sense. So when we are in debates about poverty and what to do about poverty, to some extent, blackness, of course, is the marker of need and poverty. And so on the other hand, we would understand relationally that whiteness marks privilege and material advantage. So that social welfare systems or TANF or anything like that that are designated for the poor is help for black people, right? Not help for all people, but help for black people. And in a way, it kind of serves as a kind of racially based affirmative action given to the undeserving, right? That's another way of sort of thinking about it. At the same time, this is what I think makes it complicated, is in the context of debates about poverty, the welfare mother also serves to, and whiteness in that context, because she's the opposite. Whiteness encodes class, or I should say working class identity in a certain way, is projected as disadvantaged relative to blacks who are privileged by their race. So I think about it in these terms. So if we go back to the end of slavery and the beginning of Reconstruction and think about the debates over the Freedmen's Bureau, you see a lot of opposition being made in the legislative history to the Freedmen's Bureau around the notion that a racially targeted intervention on behalf of formerly enslaved people was going to leave out the white poor. Mm-hmm. So it's in that context then that the white poor, or that whiteness actually is disadvantaged relative to blacks who are privileged by their race. So vis-a-vis the deserving white poor and working class, blackness is privileged. So all of this is to say that I'm drawing on some of these historical ideas to try to explain why this conversation is so vexed, as well as why this particular model or understanding or trope has such traction. It's because of its ability to function in multiple ways in the course of debates that both mark whiteness as advantage vis-a-vis black poverty, as well as disadvantage vis-a-vis any form of intervention. So interventions that attempt to disrupt poverty are seen as being for the benefit of black people, not for the benefit of people as a whole. And this becomes a real difficult problem in terms of our political mobilization. I've ended, I think, so I'm going to stop now.
Well, that was great, and period-wise, I'm picking up exactly where you left off. So,
great. Almost like we planned it.
I almost as if we planned it, because I was thinking, okay, is anybody else going to be talking about the 19th century? Hi, I'm Deanna Williams, and I have slides, who's in charge of the computer? Oh, I have to turn it on. I have to turn it on.
Okay.
Mira told me this very clearly. Okay, yes. All right, so I'm going to be talking about redefinitions of marriage in the aftermath of emancipation. And I'm not necessarily proposing I'm talking about a correlation, not necessarily causation, but I think more research might actually come to suggest causation as well. And I'm going to be talking about it in the context of Civil War widows' pensions. So during the Civil War, hundreds of thousands of men of color volunteered to fight in the Union Army in order to gain freedom for themselves and their families. The immediate outcome of their efforts is well known. In fighting for the nation, they made an important claim to citizenship and eventually shared in many of the privileges and pensions accorded to other veterans. These pensions included survivors' benefits for their widows. The efforts of these women and the widows of veterans who were men of color were overwhelmingly women of color. The efforts of these women to gain these benefits constituted a struggle of much longer duration than those of the veterans, and with less well-known results. Some of you may have heard there's a novel, isn't it, titled like The Last Living Confederate Widow, who's supposed to have died in like 1980 something or 60s. Anyway, it's a much longer battle and with less well-known results. In any case, abolitionists had long placed the integrity of the family at the center of their critique of slavery. And as early as 1863, before any explicit changes to marriage laws had been made, some Union Army officials in the occupied South who shared these concerns took it upon themselves to solemnize relationships between the enslaved people, or contrabands as they were then called, that they encountered. And I'm going to deviate from the reading just to call attention to this slide here. This is obviously from 1816, a quote from a legal treatise, important legal treatise called Tapping Reeve, and it speaks to sort of an American definition of marriage that some historians call Republican marriage, and this is going to be important to explain this transition. And Tapping Reeve writes, "There's nothing in the nature of a marriage contract that is more sacred than that of other contracts, that require the interposition of a person in holy orders, or that it should be solemnized in a church. Every idea of this kind entertained by any person has arisen solely from the usurpation of the Church of Rome on the rights of the civilian." Okay, then. So marriage, in other words, is a civil contract. This was understood very clearly in legal treatises, particularly in the pre-Civil War period. And you may also understand it as the essence of what we now call common law marriage, which wasn't called common law marriage until after the Civil War, during a movement to abolish it. So previously, people would say things like, marriage at common law is nothing more than a civil contract, meaning not a religious sacrament. Okay, that's Tapping Reeve. Here's another famous treatise. "No particular ceremonies are requisite by the common law to the valid celebration of marriage. The consent of the parties is all that is required." This is the language equally of the common and canon law and of common reason. That's Chancellor Kent, Commentaries in American Law, 1844. Now, what vexed this question, of course, is the question of the marriages of the enslaved. Right? And Louisiana, which is the state that I focus on, is somewhat unusual in this regard because they don't have this tradition of sort of virulent anti-Catholicism, or at least not in the same way that Tapping Reeve articulates it. And so there's actually a Louisiana Supreme Court case in 1819 which articulates what Adrian Davis has called the sort of dormancy theory of slave marriage. And here it is: "With the consent of their masters, slaves may marry, and their moral power to agree to such a contract or connection as that of marriage cannot be doubted. But whilst in a state of slavery, it cannot produce any civil effect, because slaves are deprived of all civil rights. Emancipation gives to the slave his civil rights, and a contract of marriage legal and valid by the consent of the master," so this is the person whose consent matters, "and the moral assent of the slave, from the moment of freedom, although dormant during slavery, produces all the effects which result from such a contract among free persons." So the question is, at the point of general emancipation, were slave marriages to become no longer dormant, but what's the opposite of dormant? Awake? Were they to gain their full civil effects? Now, the context of this is really important, and many of you may not be aware of the proposed but never ratified 13th Amendment of 1861. This is like the last compromise in the series of compromises leading to the Civil War. And it says as follows: "No amendment shall be made to the Constitution which will authorize or give to Congress the power to abolish or interfere within any state with the domestic institutions thereof, including that of persons held to labor or service by the laws of said state." So this is, those of you who know the 19th century know that by domestic institutions they're referring to two domestic institutions. Anyone?
Slavery.
Slavery and marriage. And marriage. Okay. As we know, the federal government did mess with slavery, right? And the question is, did it also mess with marriage? Okay, or could it? So now, this is right. I can't read this, and neither can you, but it's the text of a letter that Abraham Lincoln wrote to Charles Sumner in May of 1864, asking the question of whether widows, this is after the Fort Pillow massacre, for which the Klan founder at Nathan Bedford Forest was known, where black soldiers were basically assassinated after surrendering. Whether the widows and children, in fact, of colored soldiers who fall in our service, be placed in law the same as if their marriages were legal, so that they can have the benefit of the provisions made the widows and orphans of white soldiers. Because, of course, obviously, how do you know they're a widow if you don't subscribe to the dormancy theory? And plus, at this point, there are a number of places where emancipation has not taken effect. A month later, and this is part of the series of images that are associated with the miscegenation controversy of 1963-64, the effort mainly in the North among Northern Democrats to prevent Lincoln from being reelected. But this is a detail from one of those images, and I don't know how clearly it looks to you, but I think of sort of, you've seen a number of images associated with welfare queens. This is one that purports to be Charles Sumner introducing this Miss Dinah Arabella Araminta Squash to President Lincoln. Although all my students, whenever they see this, they always say, oh, Lincoln's marrying this couple, which I don't think is an accidental view. And then, in any ways, she replies that she knows Mrs. Lincoln because she used to do her laundry. And now she doesn't do nothing but go gallivanting around with the white gentleman. So the fear that with emancipation, the heavenly miscegenation times meant no work. And of course, the, black women dressed in sort of absurdly fancy dresses. So it's hearkening to, since you mentioned the Freedmen's Bureau, you probably had an image like this in mind. This is not gendered female, but I just wanted to sort of call attention to the relationship. Now, here is the federal government messing with marriage. Here's the federal government messing with marriage. The U.S. Civil Rights Act of 1866, which is a precursor to the 14th Amendment, saying that all persons born in the United States are hereby declared to be citizens of the United States, and such citizens of every race and color shall have the same right to make and enforce contracts as is enjoyed by white citizens. This is the first, as I understand it, piece of federal legislation to pass over a presidential veto. Andrew Johnson vetoed it, and explicitly raised the question of whether it could repeal state laws as to the contract of marriage between the two races, sort of raising the issue of miscegenation or amalgamation. Hitherto, every subject in this bill has been considered as exclusively belonging to the states. And indeed, after it passes over his veto I can at least say in Louisiana, but also in some other places, here we have General Philip Sheridan, who was the commander of the 5th Military District under military reconstruction, responding to a Louisiana clerk of court asking, do I have to give a marriage license to an interracial couple? And he responds saying, marriage being regarded as a contract only between two parties under the Civil Rights Bill, clerks of courts have the right to grant marriage licenses between whites and blacks in this or any other state in the Union, none being excluded from making contracts on account of color. This is very quickly, as other historians have pointed out, judges in not only southern courts but northern ones in the case of state of Indiana versus Gibson start redefining marriage as more than a mere civil contract. It is a public institution established by God himself, recognized in all Christian and civilized nations. So much for Tapping Reeve, 1816. If the federal government can determine who may marry in a state, there is no limit to its power. So all of that is relevant to explain the importance of the context of this pension law in 1882, which basically goes against the grain of what Lincoln was suggesting in his letter to Sumner, and indeed the text of an 1866 pension law, by saying that the marriages shall be proven in pension cases to be legal marriages according to the law of the place where the parties resided at the time of the marriage. And in my research with the pension forms, Pension Bureau decisions, appealed cases, generally speaking, they say the marriage of the place, the law of the place where the parties resided at the time of the marriage was state law, despite the fact that clearly the federal government had messed with marriage. This is just, this is a little bit out of order, but some of you may know this quote: "The marriage covenant is at the foundation of all our rights." This is a black officer to his troops in 1866. In slavery, we could not have legalized marriage. Now we have it. And indeed, there are a number of cases where, oh man, you can't read this. Or can you? I can't. I need new glasses. This is a case in 1908 in the Louisiana Supreme Court where a couple's, the legitimacy of a couple's marriage, or the legitimacy of a widow is challenged as a widow. And her son produces a marriage certificate that had been issued by a provost marshal in 1863. Of course, this is a federal official, a Union Army official. And the Louisiana Supreme Court says that we can't recognize an officer unknown to our laws, right? And that he had no right, essentially, to celebrate this marriage as a federal official. Never mind the fact that when a lot of these federal officials, you know, made a big to-do about celebrating marriages of freedmen and saying, "Yay, we're here, now you're married," they didn't necessarily, they took their records with them, right? So that basically the court rejected this as evidence of marriage in 1908. But, and this is, you certainly can't read that, although I can, but it's the kind of documentation that people had submitted to the Pension Bureau of their weddings in the mid to late 19th century. The equivalent of what I joke to my students is sort of like a note on a napkin from your minister saying, you know, yes, there's a record in the church of their marriage. That doesn't say whether or not there's a civil record. And indeed, given the number of black churches that were burned, and given the fact that Freedmen's Bureau marriage records went back to Washington after the Freedmen's Bureau was disbanded, these records were really hard to get their hands on. In any case, the attack on common law marriage starts in the post-Civil War period, and has such quotes like that. Even Elizabeth Cady Stanton, it's associated with eugenics and sort of the importance of raising barriers to marriage. And increasingly, a real marriage, this is weird, but this is from the Uniform Marriage Licensing Act of 1911, saying marriage may be validly contracted only after a license has been issued. So there's a rise in sort of formal definitions of marriage in this period. Okay, all of which is to say that the drama of wedding that accompanied emancipation and war contained an unresolved question over the subject of legal authority. Were the newly wedded claiming a transcendent right to marriage? Did their marriages become awake? Was it a new federal authority that enabled them to marry for the first time? And if so, would that federal authority be recognized by the federal authority in charge of giving out the pensions in the late 19th century as the veterans died, and as their widows came forward to claim the status as widows? And I have one example from my research involving the case of Lewis Martin, a free man of color in New Orleans who began courting Elizabeth Hurd, a slave, in the 1850s. He had obtained the permission of Elizabeth's master to have a ceremonial marriage in before a Catholic priest in 1860, which was documented in the church's records. They resumed their relationship after the war, after Lewis was discharged from the military and Elizabeth became formally free. They remained together for nearly 50 years and remarried, possibly out of a concern that they'd be able to produce the kind of documentation that the Pension Bureau required. They remarried in 1893, and then Lewis died in 1908. Elizabeth's pension application was rejected on several grounds. First, the 1860 marriage was considered null because the pre-Civil War Louisiana Civil Code had declared such mixed status marriages null and void, so it didn't even fall into the category of former slave marriages that could wake up at the point of emancipation. And moreover, according to the law of 1890, saying, okay, because the pension, as the veterans aged, the Pension Bureau was concerned that widows were simply marrying the veterans, younger and younger women marrying older and older men, seeking simply to get a pension. They changed the law saying that you had to have married before 1890. So their marriage in 1893 constituted for the Pension Bureau an admission that they hadn't considered themselves legally married before that point, and they were sort of damned if they did, damned if they don't. And I'll stop there.
I'm going to stand.
All right.
I'm going to grab the clicker. Mirror here. I'm not sure how to.
Red X in the corner out there? I have no idea what I'm doing.
Yeah, how do we get out of
I'm thinking it's on,
yeah, how do we get out of mine?
yeah, I'm just thinking you need to go,
Yeah, if you just make that one small,
yeah.
But does that have the power to do
up there
that?
in the corner, up there,
Yeah, no, there's no
you
way to
can't,
move it.
you can't move the.
So where's the
mouse.
computer that's connected?
Oh, okay, she's got it.
All right, excellent.
Okay, great. That's supposed to see.
So you wanna, no, you wanna
Oh, this isn't.
escape,
This is still mine.
Actually moving it over.
Oh, okay.
So I'll go back.
and then make that one small, go up to the top right. Yeah, the mic, the other one. No, yeah. Either the red one, either the red one or the little one.
The red button.
There you go. Click.
It's not
It's
clicking.
not clicking. Yeah, I was.
She's doing it over there with the mouse.
There we go.
Yeah.
So how do I get it into the thing? Fabulous. Thank you. All right, so here we are, the last speaker of the last panel of an incredible day, reflecting on the trope of the welfare queen and how after 50 years after its creation it's remained so enduring in the public imagination, particularly as it relates to dependence and pathology. Today we heard rich discussion, particularly from Karen and Anne, about the structural forces that lead to women's dependence on public services, including the increasingly punitive criminal justice system and child welfare system that punish women for problems that are actually the result of poverty and social inequality. For example, women of color are more likely than other groups to be arrested for distinct classes of crimes linked to motherhood, such as drug use during pregnancy, as Anne talked about, even falsifying records when they try to use somebody's address to get their child into a better school system. But these arrests can lead to another, less talked about structural factor that leads to women's dependence, which is that these women's interactions with the criminal justice system can result in the creation of a criminal record. And this information is often used by employers to deny these women jobs. And this creates a cycle of unemployment and dependence that perpetuates the welfare queen mythology. So today, nearly 1 in 3 people in the US have a criminal record. So in raw numbers, that's 65 million people who've had some involvement with the interaction with the criminal justice system that would lead to something that would turn up doing a routine background search. And women of color are the fastest growing segment of this population. Now, the overwhelming majority of people with criminal records, but particularly women of color, have them for minor or low-level offenses. And this information is readily available to employers. All it takes is a quick internet search, and you have virtually instantaneous access to the more than 93 million computerized records available online. And these records represent 30% of the US adult population. Now, just a few decades ago, conducting a criminal background check was hard to do because you had to know which administrative agencies and courts to check for relevant documents. And even if you had a sense of that the person might have a record in multiple states, you then would have to go to each one. There's a good chance you have to go to each one to find the records. Now, today, Tens of millions of criminal background checks are conducted through companies, private companies in the background checking industry. And over 90% of employers conduct these kinds of employment checks, including Walmart, let's see, the nation's largest employer and the nation's largest private employer, and a significant employment option for low-wage women of color. And nearly 3/4 of employers have adopted broad bans on the hiring of anyone with a criminal record. And here are some of the companies that have done so: Bank of America, Lowe's, Domino's Pizza, among others. And many companies even bar the hiring of people with just an arrest. And this affects lots of people. And it has a disproportionate effect on people of color because they're overrepresented in the criminal justice system relative to their percentage of the population and relative to their involvement in criminal activity. So for example, African Americans are up to 15 times more likely than whites to be arrested for low-level offenses. And with Latinos, they're 3 times more likely. And this is due in large part, to policing strategies that target minority communities, such as the war on drugs, broken windows policing, stop and frisk programs, which have become very popular among urban police forces. And as the Ferguson report shows, in some places you can get a criminal record just for being black, right? Now, not only are people of color more likely to have a criminal record, but for this group, having a criminal record is significantly worse than for whites. For example, groundbreaking audit studies conducted by researchers at Harvard and Princeton universities found that whites with a criminal record were half as likely to get a callback as whites without a record. And blacks with a criminal record were 1/3 as likely to get a callback as blacks without a criminal record. And here's the kicker. The research also showed that whites with a purported recent felony conviction had a higher chance of getting a callback than blacks without any record at all, right? And similar patterns have been found between whites and Latinos. And these findings suggest that for people of color are particularly stigmatized by having a criminal record, and indeed suffer what scholars call a criminal records penalty. And the fact that employers have virtually unlimited access to this information only intensifies the stigma, making it all but impossible for people of color with records to get jobs. Now, in my paper, I propose a framework to address this problem of stigma and discrimination, and I call it the health law framework, because it adopts from laws from the health law context. And as I'll explain, these laws work to counter discrimination and stigma preemptively. So they try to stop discrimination before it starts. So they offer a model that might be more successful than the current regulatory regime in addressing employment discrimination that stems from being a person of color and having a record. So what are the laws that are currently used to address this problem? They're Title VII of the Civil Rights Act and the Fair Credit Reporting Act. But as I'll explain, neither law goes far enough in addressing the interest of employers or potential employees. So let me start with the FCRA, the Fair Credit Reporting Act. This is a federal law that governs the distribution of criminal records by commercial background checking companies. This law says that employers have to get consent from job applicants before a background search is conducted. And employers have to notify people if they're denied a job or fired because of information contained in a report. But the law isn't adequately enforced. Employers typically get an application, do an online search, find a record, and then never call the person back. The FCRA is also supposed to ensure that the information contained in criminal reports is accurate, but it fails to do this too. Studies show, countless studies actually show that criminal history reports are riddled with errors, including the release of sealed or expunged information. Records are missing often case disposition information, such as a felony that was dropped to a misdemeanor, or cases where all the charges were dropped entirely. And they often contain misspellings or clerical errors, which can lead to false positive identifications and false negative identifications. And it's estimated that hundreds of thousands of these errors occur each year, meaning that huge numbers of people are denied employment opportunities. And the worst part is, a flawed report can circulate indefinitely. All the while, the job applicant has no idea why they can't get jobs. So that's the FCRA. And there's Title VII of the Civil Rights Act, which, among other things, prohibits employment discrimination based on race. It also bars employers from automatically denying job applicants employment because they have an arrest or a conviction record. And this is because broad bans on the hiring of people with criminal record are likely to have a disparate impact on people of color because they're statistically more likely to have a record. But Title VII, when applied to the criminal records context, produces unique problems that make it incredibly difficult for people of color with criminal records to get hired or to challenge adverse hiring decisions. And this is due to several factors. First, Title VII was created to target race discrimination, but criminal records discrimination is not like, it's different from race discrimination. So consideration of race is considered illegal in employment because race is generally understood to be irrelevant to a person's ability to function on the job. Criminal history status, on the other hand, may sometimes be quite relevant. So for example, if an employer is hiring a bank teller or an accountant, the fact that the candidate has a recent embezzlement conviction, might be relevant to an employer. Another problem is that although under Title VII, employers can consider a job applicant's criminal record when making employment decisions, the applicant's race may consciously or unconsciously negatively influence the way the employer evaluates the candidate's record. And this makes invidious discrimination very tough to detect. The final problem is criminal record discrimination. One of the reasons why both Title VII and the FCRA are unable to adequately address this type of discrimination is that it happens early in the hiring process, often before a candidate even meets with an employer. And so they have little real knowledge of why they were denied a job or an interview, and in fact may never know the real reasons for their rejection. And this makes it also very tough to challenge discriminatory actions. And finally, there's the issue of stigma. Neither the FCRA nor Title VII addresses the ways in which the combination of a criminal record and minority status creates a distinctive and powerful social stigma that studies show is significantly more harmful than minority status or ex-offender status alone. So for these reasons, neither of these laws can effectively prevent or redress discrimination. So this brings me to the health law context. A law based on health laws specifically, or a model based on health laws, specifically the Americans with Disabilities Act, which prohibits discrimination against people with physical or mental disabilities. And the other law is GINA, the Genetic Information Non-Discrimination Act, which prohibits employment discrimination against people with a genetic predisposition to develop disease. I argue that the Title VII FCRA scheme can be strengthened by incorporating aspects of the ADA and GINA, which would better account for the unique stigma that attaches to dual criminal records and minority status. This is because, here we go. First, having a disability like having a criminal record is relevant to employment discrimination, to employment decision making. And both can be used as the legitimate grounds for excluding an individual from employment. And this is never the case with race. Second, unlike Title VII and the FCRA, both the ADA and GINA were designed to target discrimination based on a trait or condition that may be invisible, but which carries a powerful social stigma. And third, in the health law context, as in the criminal record setting, employers are allowed to consider potentially stigmatizing information about employees and job candidates. Therefore, the ADA and GINA have been designed to regulate the flow of stigmatizing information in order to prevent discrimination preemptively while ensuring equality of opportunity. So, how would this work in practice? Under the ADA, an employer can't attempt to learn whether an applicant has a disability prior to making a job offer. And this is to ensure that people with disabilities have a fair opportunity to be judged on their qualifications. And then, once an offer has been made, but before the candidate begins work, an employer can ask disability-related questions. However, if an individual is denied a job because these questions reveal a disability, then the employer has to demonstrate that the exclusion is job-related and consistent with business necessity. Now, as applied to the criminal records context, employers shouldn't be able to acquire a job applicant's criminal record until after the candidate has received a conditional offer. And in keeping with GINA, employers shouldn't be able to obtain this information from online sources such as commercial databases. Now, this health law framework allows people with criminal records to get past the phase at which employers are most likely to exclude them based on their stigmatized status. And this health law framework would also make it easier for people with criminal records to prove intentional discrimination, because it forces an employer to justify rejecting an applicant after already accepting them. And in addition, the health law framework would enhance the FCRA's provisions that require an employer to get a job candidate's consent before conducting a background check, and that mandate notifying an applicant if a report is used for an adverse employment decision. So this allows the health law framework to alleviate the pervasive problems or the pervasive errors that now plague criminal history reports, and would also give a candidate a meaningful opportunity to explain, refute, or rebut, or check the veracity of a record being considered before being disqualified for employment. It would also allow a candidate to catch a conviction record that should have been expunged, or a felony offense that was later reduced to a misdemeanor, or some other error in the record. Now, employers often say they don't want to hire people with criminal records because doing so might increase their risk of tort liability due to negligent hiring or negligent retention lawsuits if the employee were to commit a crime in the workplace. In the ADA and GINA contexts, employers are similarly concerned about increased health costs or other costs that may be incurred by hiring somebody with a disability or a genetic predisposition to developing a disease. Still, the expectation under GINA and ADA is that the employer will assume the risk. So for example, under the ADA, an employer can refuse to hire someone if they can show that the person poses a significant risk of substantial harm to health or safety, but they can't refuse to hire a job candidate based on speculation about future risk or assumptions about the disability. An employer also has to consider whether a reasonable accommodation can eliminate or reduce the risk. So if the requested accommodation causes an undue hardship, which is to say, would require substantial difficulty or expense, an employer would still have to provide another accommodation that doesn't. So the reasonable accommodation mandate recognizes the employer is best able to bear the potential costs associated with hiring a disabled applicant. Now, in comparison, in the criminal records context, the assumption for many is that people with criminal records are at high risk of reoffending or committing future crimes. However, data reveals that once people with criminal records have stayed clean for a few years, their chances of reoffending virtually disappears. And this point is widely referred to as the point of redemption, which averages from between 2 and 7 years, depending on the type of offense or the age at which the arrest occurred. In addition, studies show that individuals with criminal records are less likely to commit an offense at the workplace than someone who's never been convicted. Now, this is not to suggest that there are no costs or risks associated with hiring people with criminal records, which, like all hiring, involves an element of chance. But employers are better able to assume the costs and risks involved in the hiring process than those who experience criminal records discrimination. Plus, as with the disabled, the costs of failing to facilitate employment for this population are tremendous. Many people with criminal records, but particularly women of color, are primary wage earners for their families, so employment discrimination for this population has negative third-party effects. Moreover, people with criminal records who spent time in jail and were jobless on reentry are 3 times more likely to return to prison. And incarceration expenditures today cost taxpayers $56 billion annually. Stable work, on the other hand, is among the most effective means of protecting against a return to criminal activity, reducing recidivism by as much as 40%. So although the reasonable accommodation mandate is about the allocation of costs, it also recognizes that moving employment barriers is a necessary means of reducing social marginalization and ensuring full citizenship. Now, to be sure, having a criminal record is not completely analogous to being disabled or having a genetic predisposition to developing disease, to the extent that one is born with a disability, or one can be born with a disability, while one typically earns a criminal record. But this isn't always the case, particularly for racial minorities. 1/3 of people with criminal records have never been convicted of a crime, as many criminal history reports contain only an arrest that never led to a conviction. And as I mentioned earlier, women of color are often arrested for crimes that are really just manifestations of poverty and inequality. And these types of arrests are most likely to occur in Black and Latino communities where aggressive policing and indiscriminate arrests are common. So for example, in New York, of the nearly 750,000 people stopped and detained and stopped and questioned by the NYPD, 87% were Black and 90% were white. And nearly 90% of those stopped had done nothing wrong, but these stops may result in a criminal record. Also in 2012, the NYPD was sued for ticketing and arresting thousands of people in their own buildings when they went out into the hallway to go get the mail, walk the dog, take out the trash. And these kinds of practices have been shown to be quite widespread. I mean, think the Ferguson report, right? So with respect to certain offenses, or some serious offenses, some degree of stigmatization might be appropriate. And every person with a criminal record may not be well suited to work in every job. But people with criminal records should be entitled to a second chance after paying their debt to society. They shouldn't automatically be denied the opportunity to compete for legitimate employment that would allow them to support themselves and their families and make a positive contribution to their community. Plus, individuals shouldn't suffer a lifetime employment penalty for an unsubstantiated arrest, a youthful indiscretion, a minor infraction, or even a more serious offense that occurred in the distant past. And this is exactly what's happening, and it's compounded for women of color due to the employment penalty they pay for having a criminal record. Now, this health law framework that I propose balances employee and employee interests along with social and economic costs, and enables the current Title VII FCRA framework to guarantee equal employment opportunities for those with criminal records. Now, in conclusion, I want to leave you with the story of Ayanna Sykes. She was convicted of robbing a video store here in California in 1998. And after spending 8 months in prison, she vowed to turn her life around. 13 years later, she'd had no further brushes with the law and in fact decided to pursue a career in medical administration. At 38, she earned a degree in psychology from UC Berkeley. Still, employers who were initially impressed by her credentials balked when they learned of her criminal history. And she's been turned down for more than a dozen jobs since graduating from college. So the point here isn't to excuse or to forget crime. Rather, the goal is to recognize that 14 million people are arrested each year and 2.2 million are locked up annually. And virtually all of these people will one day be released. And it's in no one's interest to keep such a large percentage of the population at the margins of society. And this is particularly true for women of color, who are often single mothers and the sole breadwinners for their families. So in essence, second chances aren't just a good idea. They're really a necessity. So, thank you.
Okay, well, thank you for a wonderful panel. We've got a fair amount of time for questions. So if I could see hands, I'm going to carry this microphone out into the crowd.
Thank you. Great presentation all day long. Literally the first one here at 9 o'clock this morning.
Wow.
Free food. Thank you. My question is, if you're saying you have an encounter with the police, you get locked up, get found not guilty, do you still have a criminal record even though you was found not guilty? Just the fact of getting locked up, even though you was found not guilty in the court of law, do you still have a criminal record when employees look up? You still have a criminal record even though you was found not guilty?
Well, no. Well, here's really the problem: is that it's the errors in records. So, arrests in most states, arrests aren't supposed to appear on criminal records. A record of arrest, it doesn't mean that you've committed any kind of criminal activity. Yet you find across states that if you do a criminal background search, you'll find records, you'll find information about arrests, even arrests where all the charges were later dropped. And people often don't know that this is in their records, but employers have access to this information. And the Fair Credit Reporting Act is supposed to police this, but it doesn't.
Thank you.
So you're from New York, and I'm not sure that you are overly familiar, but maybe this is a question for anybody here. about the passage of Proposition 47 here in California, and the box.
Ban the box.
Ban the box,
Yeah.
What are the implications here?
So ban the box laws are fantastic, and we're seeing them crop up in state and local governments all over the country. And is everybody familiar with ban the box? Okay, so so I don't know what I'm not familiar with the specifics of California, but generally, if you apply for a position at, let's say, Home Depot, or where you have to fill out an application, or Walmart, there's often a little box at the top of the application that says, "Have you ever been arrested or convicted of a crime?" You check that box, they take your application, they crumple it up, they throw it in the trash. And so many state and local governments are banning that box. They're not allowing employers to ask this question. So actually, I say Home Depot and Lowe's, but actually in most in most jurisdictions where we have this, it only applies to public employers. Okay, and
The box.
the box for public employers. Some private employers are voluntarily not asking that question, and I think actually Home Depot is one, but they're only enforcing it against public employers. Now, what this proposal would do is it would create uniformity across states. Because right now, if you have a company that's operating in multiple states, some states have it, some states don't. It would also hopefully apply to private employers as well.
But does this also mean that these employers are not allowed to do criminal checks?
Well, they wouldn't be able to until they make a conditional offer.
Employment offer.
Yeah,
Thank you.
sure.
Hi everybody. Hi, my question actually is directed directly to Professor Harris. Anyway, my name is Heather Montes Ireland. I'm a doctoral candidate in gender studies at Indiana University. And I'm doing some research right now, and I'm trying to think about a little bit more about the privatization of labor in kind of entrepreneurial solutions to poverty, like microfinance, that are often targeted specifically at Black and Latina single mothers. And so you were speaking about, which I was really, wow, you had me thinking so many things about the kind of really, really flexible position of Black women's labor that you were talking about. And I actually am just wondering if you could just talk a little bit more about that. It's kind of selfish that I'm wanting to hear more, but it really makes me think, right, about those neoliberal imperatives about what flexible labor represents today, you know, in a neoliberal economy. And so, you know, is that part of like what you're thinking and whatnot? I would just love to know more.
Okay. I've actually not thought about its contemporary applications or dimensions as much as I might, because obviously at one level the flexible worker is the ideal worker, right? I mean, I think it was Letitia who was pointing this out earlier. That is, the ideal worker is the one that you don't need to really make any long-term commitments to. You can sort of move them around. And the whole neoliberal model is built around the need to have flexibility, nimble, you know, all of those attributes. What's curious is that the flexibility or the historical ways in which Black women's labor was flexible has not carried over into the depiction of Black women as an ideal worker. If anything, it's the opposite, right? That said, I don't know whether that's the case across all racial categories of women, right? We might think of the ways in which there are differences with, say, with respect to, say, Asian women or Latinas, in terms of how these other women that are typically entering the workforce at a particular level can become substitutes for jobs that were previously held by Black women. I was really struck by Karen's example of the interview that she did about the Black woman that found herself in a predominantly Latina workforce. Certainly a lot of the manufacturing labor that occurs in Los Angeles is feminized, is, you know, Latina, is immigrant, precisely around this desire for the flexible labor. I'm thinking of what's his name's book? Waldinger's book, How the Other Half Works, where you have a lot of interviews with employers actually being fairly explicit about this, like this is what they want. They also want Asian women with little fingers. I mean, it's all really sick. Anyway, the point that I was trying to get at is, I don't know then in that context that I could make a claim about what the contemporary dimensions are of actual labor of actual black women, right? I will say, and I was trying more so to talk about the ways in which why this trope of the welfare queen continues to do so much work. But I think it is an important question that you raised about how this ties into entrepreneurial interventions to fix poverty. Because this all, I think, has to do with what gets called as work, right? Because the very same work that these women could be doing now to try to sustain themselves is not seen as work for which they get paid, but under this model that you're talking about could easily move into the notion of, oh, okay, so now you're self-employed, right? So it's something very slippery about this question, but I think it's an important one. I'm mostly at the point of speculation around it, really, but I think it's really interesting to think about. Yeah.
I'm going to take a moment then to ask a question I have, and it's also, I'll let anyone jump in, but I'm going to direct it at you because I think it fits most comfortably with the paper you gave, which is, I've been thinking, I guess across all these panels about the kind of skits you hear in comedy shows these days where upper middle class women talk about how they're going to have it all, and the joke is that they can't, right? And one of the themes of a lot of the papers, including yours, is how we expect working class black women or poor black women to be able to do all these things at once, and that's really kind of a terrible burden to carry. And that there's a sort of failure of empathy across class and race lines. And I guess I'm curious if you have thoughts on why there hasn't been more success building coalitions around that kind of, like, it seems like not exactly a shared struggle, but a similar set of problems. And yet there's been a kind of signal failure for that to be a rallying point.
So it's interesting to think about this as a set of sort of what might be classically characterized as issues around which there should be some solidarity among women, right? Meaning a set of impossible demands, even allowing for sort of people being very differentially situated. I think I was trying to say something about why, or what interrupts that empathy, or what interrupts that is the ways in which poverty is racially encoded. And I mean, fundamentally, I think somebody else said this earlier, nobody wants to identify as poor. Even the poor don't want to identify as poor. Everybody identifies as middle class. The rich identify as middle class. There's a kind of way in which the identification of poverty is both unnamed in the way that Karin was talking about, even in the context of discussions about inequality, you can't say poverty, so it has something to do with the racialization of poverty as a stigmatized status that no one wants to identify with, even the people that are in that condition. And the second part of it has to do with the ways in which the privileges attached, the racial privileges, depend upon that distancing or that subordination. So the disruption, there's an awful, I guess I say, awful lot of fences to get over, and in the context of a neoliberal sort of refashioning of work, highly risky. right? So if we think about this as a moment in which the position of the white middle class and upper middle class is more unstable, say, than it was 30 years ago, for all the sets of reasons that we've talked about, it's very risky. And as Bernice Reagan once famously said, coalition is the most dangerous work, and depends upon a set of relationships and trust that's often very hard to do. What will be interesting, not particularly optimistic, but what will be interesting to see is how, for example, in the context of Hillary Clinton's campaign, whether or not any of this surfaces. We're told now that she's actually going to campaign as a woman, right? No, really, I mean, seriously, this is what they're saying. Last time she tried not to talk about it. This time it's all about Hillary, the mom, the grandmom, the woman. I really get the woman thing. But I don't know whether or not any of this is going to be touched. Certainly I think there's arguments for why we should push to have it there. But I think this is an interesting moment to see whether or not there's any real estate in there that can be, covered. I'm not real optimistic, but I'm just saying.
Well, I wouldn't know. Oh, yes.
One? Yeah.
I'll go back to one of the points you were bringing up that made me think a lot about racial profiling as you were describing what employers were doing when they were considering criminal records, making inferences on the basis of those criminal records, statistical inferences, saying he poses a heightened risk because he or she comes from this background, this criminal background, and you would compare that to Americans with disabilities and how they're processed in the employment context, and how allowances are made and accommodations are made, even if they pose a heightened risk because of their disability. And so as you were talking about that, it was just fascinating to me, kind of the profiling connections, the statistical rationality, analogs, and what comes to mind with respect to disabilities and tort law is we will hold someone to a standard of care of a reasonable person with that disability, i.e., you get to generate more risks than an ordinary person who doesn't have a disability, a prosthetic arm, for example, and you aren't going to be held accountable for the greater risk. And why? Because it's important for us to make sure that you can participate in core community activities with the rest of us. And if we hold you to the standard of an ordinary person without a disability, then you're going to get insured out, the insurance rates are going to be crazy, or you're just not going to be able to participate. So we subsidize your participation because it's that important to us for you to be a core member of our community. Can we get them to think perhaps that way about racial identity as a kind of social disability that may have some attendant risks, that may be higher, but they're worth paying the cost for to make sure that we can have core, full participation in core community activities by people from this social group?
So racial identity. So I've been thinking about it in terms of, criminal record and racial identity together. How do you think about that? Any thoughts on? Yeah. That's interesting, particularly the correlation between the way tort law understands the reasonable person.
Yeah, profiling is profiling. It's basing your judgments on statistical generalizations that have a risk of error associated with them, and the question becomes how much are you willing to pay despite that additional risk of error. We do that all the time, and we pay high prices for sometimes very small things, like you can get to grandma's house or granddad's house a little faster on Saturday by going 75 miles an hour than 65 miles an hour. We know it's going to cost lives, but we say we're willing to spend those lives for that added convenience. Here's something, equality, that is a much loftier value that we could spend some risk for, but aren't they worth it?
I think someone wants to respond to yours.
It's another thought, and it's not an optimistic thought, but it's a thought anyway, which is that it makes me think about, why was it decided, what was the motivation for deciding that we should have the ADA and that people should be incorporated into the mainstream of society, so to speak. And part of it was specifically because we didn't want people to be getting benefits. We wanted people not to be relying on the state, and we wanted people to be working for their pay and working to take care of themselves. And the idea was we want these people to be part of our market economy, our market way of doing things. And so, could one use the same logic here? Do we want to? I mean, that's another question. But in theory, that sort of brings me full circle to some of the, the welfare legislation of 1996, right? I mean, what is the goal that we're trying to seek, and what kind of incorporation into what kind of mainstream are we interested in?
Okay, well, I think we've run out of time, so as we route our microphone to Camille Rich to give us some closing remarks, why don't we give our panelists 1 minute.
So when Sam said closing remarks, I'm sure all of you may have sort of had this moment of anxiety that I was going to be up here a long time, but I'm not. I'm going to be remarkably brief. I wanted to start off by saying thank you to Mira and her team for doing and also to thank all of the various faculty members that participated in making this event great. Claire, for all your help, and Sam and Jody as well, and just all the support that I received. So thank you for that. The final thing I wanted to close with was actually another thing that was produced by my sort of first time out planning a conference, which was there was a lot of discussion about what the title of this conference should be. And you'll notice as the materials evolved over time, the name of the conference kept changing. And I wanted to call it Reclaiming the Welfare Queen. I was convinced to call it Reframing, which is a little bit more objective and distancing. And people said, why would you want to reclaim a welfare queen? People are not going to understand what it is you're talking about. But what I meant by reclaiming was at a number of levels. One is a sort of act of redemption and sort of claiming your connection to need-based programs, not being ashamed of that history. I think that that's an important part of reclaiming the welfare queen. I also think it's about empathy, which is also an important starting point in thinking about policy alternatives, is to actually relate to and understand and connect with people who have this current involvement in need-based programs, even if that's not where you are at present. And then finally, as a strategic matter, I wanted to say that we should not automatically assume that the demands made by the so-called fictional welfare queen are quite so problematic after all. So in my initial comments, I wanted to point to a number of things that the welfare queen, supposed welfare queen, was asking for that maybe aren't so crazy after all. That is, she believes her care is the best care for her child. That is, she doesn't define her identity by market participation. And that she believes the state has a true obligation to assist her, right, in exercising reproductive freedom. So I hope the presentations today, I know we've done a lot of things over the course of the presentations today that are very important, but there are 3 different ways that we can sort of think about this goal of reclaiming the welfare queen that I want to leave you with, and then you'll use your own, sort of insights in thinking about the presentations to work that out for yourself. But one thing is definitional. Some of the presentations have asked, how do we define what caregiving is? If we think the welfare queen believes her care is the best for her child, well, how do we define what caregiving is? Is it participating in wage labor? Is it staying at home with your child? That's a big debate that's been going on in feminist legal circles for a very long time, but this actually brackets the question in a new frame. We also talked about structural and economic impediments to providing care, and I think that's an important thing to think about in the definitional status as well. And then we also talked about the redeployment of this caregiving trope. That is, it's now being raised in a way that suggests that women should be criminalized for not providing care for their child. So all of these, abuse and neglect proceedings are actually proceeding along the same line of mothering and caregiving and what that means. But I think the hopeful layer that I think that we were just starting to get to at the end of each panel is thinking about this from an empowerment perspective, right? That is, if we know mothering and caregiving is important to these women, we know this discourse is being used to punish them. We know there are all these questions about how to define what caregiving is, and we have an opportunity to draw out, right, some of the inconsistencies and the demands that are being placed on these women. You can't be an ideal worker and be an ideal mother at the same time, and this is something women across, right, the class spectrum are negotiating and dealing with now. And that provides us for an opportunity for productive conversations and productive interventions. And I think we can do that with each of the various things I laid out in terms of how the welfare queen is constructed, and that may provide, even if some of the presentations didn't seem quite so helpful at the end, they're important sort of depressing moments to engage with in order to get to that more productive place. So I thank you all for helping me think through these issues and providing me with so much information that was enriching, and I think anyone who watches the video presentation and who was here today participating in the conference had the same experience. But thank you all for coming, and thank you again.